All right, ladies and gentlemen, shall we return? Thank you very much. Do we have any housekeeping items before we move to rebuttal? Mr. Kehoe?
None from the claimants, Mr. President.
Mr. Hamilton?
None, Mr. President. Thank you.
All right. Thank you very much. All right, then let's hear from Peru, if we could, please, in rebuttal. Thank you.
¿Dónde está? Ustedes controlan. Mr. President, members of the tribunal, thank you very much for your attention. Peru will now address various arguments raised by Renco during its arguments of today. And there were four main arguments that Renco raised. The first related to the scope of the treaty's waiver requirement. The second, the ability to cure any alleged defect. The third, claims related to the local enterprise, Do Run Peru. And finally, so-called defensive actions as an alleged exception to the waiver requirement. My colleagues and I will address each of these issues in turn. First, the scope of the treaty's written waiver requirement. The most notable thing about Renco's argument before this tribunal is how long it took Renco to get around to what the treaty actually says with respect to waiver. We heard a lot of preliminaries, general principles of interpretation, how to make different pieces fit together, and general principles of reading a treaty and the governing law. But of course, the first place to look in terms of what is binding on this tribunal is what the plain language of the waiver requirement says. And with respect to that plain language, there appears to be a basic agreement between the two parties to the treaty, Peru and the United States, with respect to the scope of that requirement and its implications. Article 10.18.2b, Conditions and Limitations on Consent, is clear. No claim may be submitted to arbitration unless the waiver requirement is met. What we heard in great detail today were many different ways to try to get around the fundamental requirement that this waiver requirement be met at the outset of the proceeding, otherwise consent is vitiated. One thing of note, there's only one exception to the waiver requirement set forth in the plain language of the treaty. And it was not a focal point of Renco's discussion. That is Article 10.18.3, Conditions and Limitations on Consent with respect to interim injunctive relief, the so-called medida cautelar under Peruvian law. Renco instead has tried to invent new exceptions to the waiver requirement that suit Renco, although they are not set forth in the plain language of the treaty, including various outs that it wants to provide for itself despite its lack of compliance with the waiver requirement. Among other things, it claims that the waiver requirement is not as absolute as the language says it is, that it can be cured later on despite the plain language and requirement of the treaty, and that there's a special exception for alleged defensive actions, which is incorrect and in any event inapplicable, as the local proceedings are not so-called defensive actions in the way that Renco seeks to contend. Renco also does not dispute that there's both a formal and material component to the waiver requirements. Renco disputes that its waiver language is insufficient, and Ms. Miniker is going to address that in greater detail in a moment. But certainly Renco does not dispute that there also is a material requirement related to compliance with the waiver requirement, and that is the so-called defensive actions argument, which we will also address in further detail. Next. And so at the end of the day, we're left with where we began, which is the plain language of the treaty requiring absolute written waivers, which are not present here with respect to Renco R to DRP, and material compliance, which also is not present here because the local proceedings do not fall within the sole exception to the treaty requirement. Next slide. Ms. Miniker now will address the issue of the written waiver requirement as well as the issue of no ability to cure.
Thank you, Mr. President, members of the tribunal, and good afternoon. On the written waiver requirement, just in response to Mr. Landau's question that I had left open, I just do want to confirm that the objection that we are, making, that we have made throughout, is with respect to the reservation taken, and that sentence in paragraph 19 was not intended to raise an additional objection with respect to the written waiver. So this morning we heard Renco make several arguments against our objection regarding the written waiver on the grounds that our interpretation contravenes the object and purpose of the treaty. Initially, we would note that the object and purpose cannot override the plain terms, the ordinary meaning of the terms of the treaty taken in context. They are used to inform the interpretation of the treaty, but cannot be used to disregard the ordinary meaning in context. And moreover, we disagree with their very limited interpretation of the object and purpose of the treaty and the dispute resolution mechanisms in particular. The waiver provision must be read together with the no U-turn provision. Those provisions operate in tandem. They are they are opposite sides of the same coin, so to speak, but they operate together. And it's clear that they operate differently than a fork in the road provision. And it's simply incorrect that the only purpose that they serve is to prevent double recovery or to ensure finality of a claim on its merits. We maintain that a purpose of the structure of the treaty is to encourage resort to local courts, to encourage investors to pursue their claims in local courts, to try to obtain a favorable result, a result that will not require resort to then international arbitration. So you don't need to internationalize the dispute. And clearly that is different from a fork in the road provision. And I would just point the tribunal's attention to the Detroit Bridge case, because counsel did say that no tribunal seemed to recognize this purported objective of the treaty. And in paragraph 318 of that case, the tribunal states that the logic behind Article 1121, which is the waiver provision in the NAFTA, is evident. It is to allow the investor quickly to start an action in the court of the host state to resolve its dispute, without prejudice to the possibility of subsequent resort to an international arbitration tribunal should the investor still consider that the treaty standards have not been met and decide to abandon the action in the host state's courts. And I think that is in line with what Peru has been discussing. And finally, on the object and purpose point, Renco's argument that the treaty language needs to be interpreted in the context of an object and purpose of effective means of dispute resolution, and that means that there must be a determination of the claim on the merits, simply is incorrect. I mean, taken to its extreme, that would mean that any time a tribunal dismissed a claim for lack of jurisdiction, there had been no effective means of dispute settlement, and that clearly is incorrect. With respect to Renco's arguments made regarding their allegation that their reservation is simply superfluous, this morning, as the tribunal noted, I raised numerous hypotheticals for general examples of when the reservation very arguably might not at all be superfluous, and where Peru would certainly be entitled to raise the waiver as a defense to the institution of a new claim in local proceedings. And Renco did not respond to that. To be clear, the objection that or the point that we were making was not with respect to the interpretation of the word claims in their reservation. It was precisely as Mr. Landau pointed out, that not all jurisdictional dismissals are the same. One can have a case dismissed on jurisdictional or admissibility grounds on a number of different grounds. And while there may be some of those dismissals that give rise to no res judicata effect, and also some of those dismissals where a waiver would not preclude the commencement of a new proceeding, there are certainly other dismissals on jurisdictional and admissibility grounds that could give rise both to res judicata effect and also where a waiver could be used to preclude the commencement of those proceedings. And what Renco would have this tribunal determine is that Peru is limited to only making res judicata defenses and is not entitled to the benefit of the waiver. If that were true, there would be no waiver provision in the treaty because the state always has the ability to argue res judicata. The waiver provision provides an additional protection to the state that it is entitled to use. And what its argument would lead to is a round of protracted negotiations with the state over the scope of the waiver, under which circumstances would a jurisdictional or admissibility defense give rise to a decision that would permit the claimant to constitute to commence a proceeding in a local forum and not be precluded by its waiver, and which ones would the state be entitled to rely upon the waiver. And clearly, that is not what is intended by the tribunal. By the treaty, Peru is entitled to a clean waiver. It is entitled to an absolute waiver that comports with the treaty's language. And then, again, as we discussed this morning, it would be for any future court or tribunal to determine whether a future subsequent suit was precluded by that waiver. And with respect to the ability to cure, as Renco acknowledged today, both the United States and Peru, the parties to the treaty, agree that the claimant cannot unilaterally submit a new waiver to remedy a defective waiver. And Renco said this morning, well, that's okay because tribunals sometimes disagree with the views of the non-disputing party. But here you have more than just the views of the non-disputed party. You have the views of both parties, the only parties to the treaty. And under the Vienna Convention, Article 31(3), A and B, there shall be taken into account, together with the context of the treaty, any subsequent agreement between the parties regarding the interpretation of the treaty or application of its provisions, and any subsequent practice in the application of the treaty which establishes the agreement of the parties regarding its interpretation. So we submit that that agreement between the parties, and both in practice and the actual agreement, shall be taken into account by this tribunal. And tribunals that have addressed this question have agreed as well, and we've discussed a lot of those this morning, including the Detroit Bridge Tribunal, the Commerce Group Tribunal, the RDC Tribunal. Renco relies primarily on the Thunderbird case. There, again, that case is distinguishable on a number of grounds. First, there was no non-conforming waiver in that case. It was only an issue of the timing of the submission of that waiver, that there was not a waiver submitted with a notice of arbitration. It was submitted with a statement of claim. There, again, it was under the NAFTA, where there was a debate between a number of tribunals as to whether, when it said submission of a claim, whether that needed to be along with the notice of arbitration or not. That was, any ambiguity there was taken away in our treaty, where it says that the waiver needs to be submitted with the notice of arbitration, and also in order to make clear that this was an issue of consent and that there was no consent to arbitrate. Absent that, the title of the provision was also changed to say conditions and limitations on consent. And I would just direct the tribunal's attention to the Methanex case there, where there was a so-called formal defect. And again, there it was only because the United States, the respondent in that case, agreed to accept the resubmitted waiver that the tribunal said that then they would go ahead with the case. But absent that, they recognized that they themselves without ruling on whether or not the waiver conformed or not, that they themselves would not have had the ability to accept the conforming waiver. Finally, on this point, Renco was wrong this morning when it argued that jurisdiction need not be established as of the date of the notice of arbitration. Not only do both of the state parties to the treaty agree on that, and all of the jurisprudence is also on point. Renco relied today on several cases from the ICJ. None of them involved a treaty where that expressly conditioned the consent of the court to a conditioned precedent like the submission of a waiver, and also those cases are all distinguishable on their facts. And specifically, they referred to the Mavromatis case from the PCIJ back in the 1920s. There was a challenge to jurisdiction on the ground that the treaty at issue had not been, the deposit of ratifications had not yet been completed as of the time of the submission of the dispute to the court. And the court ruled in accepting jurisdiction that an essential characteristic of this protocol, I'm sorry, it was a protocol to a treaty that had, the ratification hadn't been deposited, and they said that an essential characteristic of the protocol was that its effects extend to legal situations dating from a time previous to its own existence. And if provision were not made in the clauses of the protocol for the protection of the rights recognized therein as against infringements before coming into force of that instrument, the protocol would be ineffective as regards the very period at which the rights in question are most in need of protection. And similarly, the other case that they noted this morning was the Bosnia and Herzegovina case. There also, the court noted that the parties in that case were bound by the convention, the Convention Against Genocide, when the application itself was filed, even though they might not have been bound as between themselves. And they cited the Mavromatis case as well. So on that, I will turn it back over. Okay, sorry, I will now make just a few comments on the issue of whether the second violation that we've discussed, which is the lack of the waiver by the enterprise. Now, one issue is that Renco has focused nearly exclusively on its expropriation claim in arguing that for an expropriation, that is necessarily a claim that is made on the investor's own behalf and not on behalf of the enterprise. And for the reasons discussed this morning, we disagree with that. But the tribunal should keep in mind that they allege the same facts and the same measures give rise also, in addition to an expropriation claim, to claims of fair and equitable treatment and national treatment. And those, again, are measures that are taken against the enterprise, and they are claiming for their indirect harm as a result of those injuries that are allegedly sustained by the enterprise. Today, Renco relied heavily on the Pope and Talbot case and said that in that case, the tribunal specifically said it was okay for the claimant to bring its claim under Article 1116 of the treaty for losses that it sustained as a result of its interest in the enterprise. And I'd ask you again to just take a look at the NAFTA article. Okay, 1121. And you can see here again, it had the claims under Article 1116 for claims brought by the claimant and 1117 for claims brought by the enterprise. But you can see in 1116 1B, it says there the investor, and where the claim is for loss and damage to an interest in an enterprise of another party, that is a juridical person that's owned or controlled by the claimant, the enterprise has to waive its right. That is the language that was quoted by Pope and Talbot when it said that a claimant could bring a claim for loss and damage to an interest in an enterprise that it owns or controls under Article 1116. So that's the exact language. They said, well, Canada had argued, no, 1116 is for direct injuries, Article 1117 is for indirect injuries, and if the injury is to a loss that you suffer to an interest in your enterprise, you have to bring it under 1117. And the Pope and Talbot Tribunal looked at the NAFTA's language and said, no, you clearly can bring it under 1116. It says that here. Under the treaty, that is what the parties deleted. So if you look at the Peru-US FTA here, there is no indication there. There's no similar language that says you can bring a claim on your own behalf for loss of your interest in an enterprise. That's what was taken out to get rid of this ambiguity, because the parties in the NAFTA had consistently maintained a distinction between 1116 and 1117, but it was that clause that so-called muddied that distinction. Now, what Renco has said today was that they took out that language, and all that meant was that you could still bring a claim for a loss or damage to your interest in an enterprise, but you just didn't have to supply a waiver for that enterprise. That was the only result of that language coming out. And in fact, they went so far as to say that that language was removed in order to conform with the Pope and Talbot decision. That clearly is incorrect, because the United States and Canada are on record, not only in the Pope and Talbot decision, but in the UPS decision and in many of the other NAFTA decisions, disagreeing with that interpretation and maintaining the distinction between 1116 and 1117. So when the United States then enters into post-NAFTA treaties, and it is making a revision, it's certainly not to conform the language of the treaty to the Pope decision with which they disagree. It's to get rid of the clause that was producing this ambiguity that tribunals were latching onto to say, certainly you can bring a claim for indirect injuries on your own behalf if you own the enterprise. So that's what was done. So now they have clearly maintained the distinction between the direct injury and the indirect injury, and what Renco again would have the tribunal determine is that despite trying to clarify and maintain this distinction, that they then said, well, no, we're not going to maintain it, and as opposed to in the NAFTA, when you could bring a claim on your own behalf for the damage to your enterprise and you had to provide an enterprise waiver, now we're going to still let you do that and you don't even have to provide the waiver. And that makes no sense, particularly in light of the fact that, as we've shown, if anything, the parties were tightening the waiver requirement. They were restricting the parallel proceedings or the additional local proceedings that you would be permitted to bring, notwithstanding your waiver. And those were limited to the interim injunctive relief in order to preserve the parties' rights during the pendency of the arbitration, and not just any proceeding that weren't for damages. Okay. And on that, I'll turn it over to Mr. Hamilton. Yes.
Renco is trying to reinvent the plain language of the treaty because it simply does not suit Renco. With respect to the requirement of an absolute written waiver, Renco stated this morning that it was open to withdrawing the reservation to its waiver on the condition that Peru agreed to various things. Renco does not get to rewrite the treaty negotiated and ratified by Peru and the United States. Instead of Renco imposing new requirements on Peru, the treaty imposes the requirements on Renco, and the requirement is absolute. And to be clear, there is no defensive proceeding exception articulated under the treaty or contemplated under the treaty. Now, today we heard about, next slide please, the plain facts. And there's a reason that Peru set out these basic facts in the memorial on waiver in its Annex A, which is that these are the plain facts that show the relationship between the local proceedings and the treaty proceeding that on its face constitutes a violation of the waiver requirement. Now, it's very helpful that Renco pointed out that its argument and defense on the waiver issue goes far afield from the plain language of the treaty requirement. Next slide.
Hamilton,
Yes.
isn't the bankruptcy a relevant fact? And why is it not shown on that slide?
It's an optimal question because that is what we're discussing right here.
Okay.
The origins of the bankruptcy proceeding. effectively form the basis of Renco's defense. It basically says, in a nutshell, Renco is a victim and it had no choice but to violate the waiver requirement. Because it's a victim, because it does not like the alleged actions of the Peruvian state, and in particular, the Ministry of Energy and Mines, Renco is able to violate the waiver requirement, or ignore the waiver requirement, or expand the exception to the waiver requirement, because this relates to a bankruptcy proceeding. And what Renco then does is it describes the bankruptcy proceeding in an inaccurate and incomplete manner without explaining, of course, the origins of the bankruptcy proceeding, why the Ministry of Energy and Mines has a credit in the bankruptcy proceeding, and all of the other facts, which is, if you take a look at the diagram here on page 13, which we set out earlier, include various other antecedents. And I've laid out some of them on the right side there, which are taken from an annex that we put into the record almost a year ago, relating to all of the things that happened before the treaty came into force with respect to environmental compliance, U.S. litigation, and subsequently the basis for the credit of the Ministry of Energy and Mines. Of course, it is Peru's position that its credit in the bankruptcy proceeding derives from the violation of Peruvian law by Renco, in violation of the contract, in violation of Peruvian law, in violation of the treaty. And so with respect to who's the victim first here, that's not an exception to the waiver requirement set out in the treaty. That's something that Renco has invented to try to defend itself. And it's tried to do it in a very particular way, which is it has tried to contend that these are not proceedings or complaints that Do Run Peru filed, that these are merely next steps in an ongoing proceeding. Therefore, they do not constitute proceedings that DRP has commenced, initiated, continued in violation of the waiver requirement. That too is inaccurate. Next slide. Now, we saw a slide this morning from Renco citing to an Indicopy document, a footnote in a document, and Renco had translated this document to say this resolution may be appealed. And Renco utilized this concept of appeal in an effort to suggest that this is all just lumped into one big bankruptcy proceeding, and this is a step that it had to take as part of that proceeding, as opposed to the choice that the treaty presents to Renco, which is a choice between different dispute resolution options, as reflected in the waiver requirement. If you look at the actual text in the Spanish language of the reference document, it does not say appeal or apelación, the term and concept that Renco played upon to try to suggest this is all just one ongoing proceeding. Rather, there's reference to the concept of impugnada. Ms. Tovar is going to discuss how this is a critical difference and only underscores the original point of the Peruvian government, which is that this is not one unified, ongoing bankruptcy process. In fact, Do Run Peru, controlled by Renco, chose to raise complaints, to file complaints in local proceedings, and that, of course, is the nub of the violation of the waiver restriction. Ms. Tovar.
Chairman's permission.
Mr. Hamilton, if the tribunal gets to the point where it needs to characterize whether or not the amparo and the administrative challenge are defensive in nature, and whether such defensive proceedings are encompassed by the waiver prohibition or exceptions, I should say. Is it your position? Is it Peru's position that we have enough information with respect to the nature of the proceedings, the knowledge of Peruvian bankruptcy legislation before us to carry out this exercise and issue a decision, an informed decision?
Thank you very much for the question, Mr. Fortier, and I believe it echoes a question that you asked this morning with respect to the state of the record before the tribunal as to issues of Peruvian law. Now, in the first place, of course, I need to say that there's no basis to analyze whether there is a defensive proceeding because the treaty does not authorize such an investigation. But in any event, assuming that would be a question that might be explored, Peru's position is that it has already created a strong record with respect to these issues, and that it's the basic concept of the waiver requirement that the tribunal need not enter into long and lengthy investigations of factual antecedents in order to determine whether there's been a violation. That said, given that we still have a little time here, we might make a brief consultation among ourselves as to whether we have any further comment in this regard. Now, we will come back one more time before we leave. Let me invite Ms. Tovar to address this issue and some other points of Peruvian law that we want to highlight.
Mention has been made by Renco has mentioned that it did not initiate nor did it continue the bankruptcy process to show that it is a defensive process. Now, I think we should make a few comments with regard what the bankruptcy process is like in Peru. It is really not very different. That is, the standards on bankruptcy in Peru are not very different from other bankruptcy standards. And as a matter of fact, the bankruptcy of a company can be initiated, be it at the request of the debtor or at the request of some creditor. So the one that is called voluntary is the one that is begun by the debtor, and the one that is called involuntary is the one that is requested by another creditor. And given this request by other creditors, it's good to know what are the debtor's alternatives. And these alternatives are in Article 28.11 of the bankruptcy law, which is a simple article, easy to understand. What it says is that the debtor, when the bankruptcy is requested by a creditor, has four options. He can pay, he can offer to pay, he can oppose the existence of that credit, of that claim, or he can support the decision. What he decided was to do that last one. So this is somewhat different from opposing himself to the existence of the credit claim that began the bankruptcy. And in order to define this well and to see what this process is all about, to see if the bankruptcy process itself can be defined as defensive in this context, we have to look at the following. And in addition, after you begin the bankruptcy process, one calls the creditors so that they appear. And in this process, the various creditors submit their claims. Not only the debtor can oppose this claim, this credit claim that has been submitted, such as that of the Ministry of Energy and Mines. Any other creditor can also oppose a claim, and that is what is established by Article 38.5 and Article 116 of the law. So, to point out that it was defensive, I think is not accurate. It does not correctly define the process. It is a process to take the bankruptcy or to carry out the bankruptcy of debtor in an orderly fashion. And I would like to draw your attention to one specific issue, because Renco has said that its only option was to question the credit claim by the Ministry of Energy and Mines, first administratively, and then, when the administrative procedure concluded, to take it before the courts. What it does not say is that no other creditor questioned or challenged the claim by the Ministry of Energy and Mines. So this obligation that apparently is brought up, that they necessarily had to do this to protect other creditors through this action, that is not a reasonable assertion, because the only one who had actually challenged this credit claim was the debtor himself under Renco's control. Finally, and before going into the language itself, if truly it had to feel compelled to question the claims that might have been opposed to, we have to say that it never challenged or disputed or took before courts the claim by the Doe Run, because that claim was questioned by one of the creditors, but it ended up in the COPI tribunal, and it would appear that there was no obligation of taking that claim to a judicial process or through a judicial proceeding and then challenge it there. In the resolution that acknowledges the claim by the Ministry of Energy and Mines, that is where we have this paragraph that I mentioned this morning, which I think does not mean what Renco has said it means. It simply means that by putting an end to the administrative proceeding, you set through officially that the administrative proceeding has concluded. And we mention, or it mentions that it can be challenged under other standards, and that is the contentious administrative standards. If we wanted to draw your attention to this involuntary mistake that my colleague made by calling it an appeal, actually it says challenge, impugnar. And it's not an appeal, that is. An impugnación is a challenge, not an appeal. And what they say there is that once the legal proceeding has concluded, there is a judicial proceeding to which they could go voluntarily, anyone who wishes to establish a judicial proceeding under Peruvian rules. Those are my comments with regard to this definition as a defense of Doe, that is, of Doe Run's defensive actions.
As well. I'm sorry? Ms. Miniker is going to make a few comments on this issue.
Thank you. So with respect to the ongoing local proceedings, Renco began its discussion of that by saying that this is only relevant if the tribunal either finds that there's no formal defect in Renco's waiver or it is able to cure it, or if it finds that DRP needed to submit a waiver. What it did not respond to at all was Peru's objection that DRP violated the waiver during the time when it had submitted the waiver, during the time between the notice of arbitration and the amended notice of arbitration, and we heard no response to that this morning. Now, Renco also argued that they had no choice to commence these proceedings and continue these proceedings because otherwise the measures may have become final. But again, that is often the case. In fact, one would venture to say always the case. In nearly, I think, every judicial system, there are certain statutes of limitations. So if you are unsatisfied with any type of a measure, even if it's a contract claim or whatever it is, you are only going to have a certain amount of time when you are able to challenge that, and then it will become final. That's just a an aspect of judicial systems, and that cannot be a reason to permit an exception to the waiver requirement. Now, again, Renco is solely relying on fork-in-the-road cases, which we've explained why we believe that they are inopposite, but in particular, with respect to some of the cases that they discussed this morning, I would just direct the tribunal's attention to our reply in footnote 81. And specifically, while Renco this morning mentioned CMS, in particular, you will see there that we indicate in the CMS case, it's true that the party had argued that the fork-in-the-road provision was not triggered because the action was defensive, but the tribunal did not rule on that basis at all, one way or the other. What it ruled was that the fork-in-the-road provision was not triggered because the causes of action were different and the local proceedings were different. And that, again, just goes to show that the fork-in-the-road provisions are generally construed much in a narrow fashion. It's much different than a waiver provision where you're looking at whether the measures are the same. Here you were looking at whether the causes of action were the same. And again, they discuss the Enron decision, and that is in the next citation there. And part of the tribunal's, what prompted the tribunal to find that there was no trigger there was apparently the agency, the regulatory agency that was entrusted with the regulation of the gas sector there, somehow the claimant was ordered by that regulatory agency to oppose or to commence these proceedings. So, in the end, this is not, again, a fork-in-the-road case. They rely heavily on Occidental because the tribunal there did seem to be sympathetic to an argument that the claimant was under time constraints and needed to make a decision quickly, and they were sympathetic to the fact that they did not want the claimant to perhaps inadvertently trigger the fork and lose its rights to international arbitration, and that's not at all what's going on here. The claimant was under no time pressure in that regard. It could have commenced its arbitration proceeding simply with respect to the St. Louis lawsuits, which, by the way, just to clarify, we have never argued that those are claims that are made on behalf of DRP. We recognize that those are claims that are made on behalf of Renco. That's an example of a direct injury to Renco. But it could have proceeded in arbitration with those claims. And then it could have continued with the bankruptcy proceedings and made any of the challenges in local courts that it wanted to with respect to MEM's credit in the Peruvian courts, and waited until those proceedings played out and then determined whether or not it wanted to bring a claim in international arbitration for those measures. Or it could have decided not to challenge them and instead come to arbitration. But what it can't do is to do both simultaneously, where Peru is now fighting on two different fronts for the same measures. And, okay. And then just very briefly on the consequences of a finding of a violation. If the tribunal finds that Renco's waiver is defective, then the consequence of that is that all of its claims are dismissed. If it finds that DRP has violated the waiver by initiating and or continuing these local proceedings, even under their construction at a very minimum, all of their claims that relate to the bankruptcy, to the MEM's credit, but more specifically to the bankruptcy, generally would be dismissed. And I'd point the tribunal's attention to the United States' second submission in paragraph 10 and note 12, where they say, and Peru agrees, that relating to must be construed broadly, and jurisprudence supports that. The reason why we say that all of the claims and not just those that relate to the bankruptcy would need to be dismissed are for the reasons I discussed earlier today, which is for the same reasons that a tribunal cannot remedy a defective waiver. It can't expand the scope of the waiver to include additional measures. It also can't retroactively restrict the scope of the measure. And of course, if the tribunal finds that DRP should have submitted a waiver and it's a violation because it didn't, then all of the claims that Renco has made on behalf of DRP or for losses or damage to its interest in DRP then would have to be dismissed, and not only the so-called bankruptcy-related measures. Thank you.
conclusion in 1 or 2 minutes. Next slide, please. It is clear that Renco is using different proceedings in different ways, including in violation of the waiver requirement, to try to benefit Renco. There's a reason why it filed the treaty arbitration, among other things, to go and use the treaty arbitration defensively in the U.S. litigation. At the same time as it was continuing to advance claims, not mere part of the bankruptcy proceeding, but an independent first proceeding and second proceeding, decisions that DRP, under control of Renco, made that other creditors did not make at that time, although part of the same creditor committee in which DRC has participated over time. So it is clear what is going on here. The language of the waiver requirement is clear. The violation is clear. And finally, the consequences are clear, as Ms. Miniker just set out, and also, as indicated on the last slide, as the United States makes clear in its submission to the tribunal of yesterday. A claim can be submitted and the arbitration can properly commence only if a claimant submits an effective waiver and complies both in form and in deed. Renco has not. Thank you.
All right, thank you very much. Either of my colleagues have any questions for Peru? No? All right, thank you. Mr. Kehoe.
Yes, I'm prepared to begin. I am wondering whether or not we might streamline our rebuttal, because we just heard what they said. If I was able to take 5 minutes with the team, that might actually speed things up, actually.
Any objection to that, Mr. Hamilton?
It's up to the tribunal. Thank you.
I think we're happy to allow that, Mr. Kehoe. Then we'll just break very quickly for
Yeah.
5 minutes. Thank you.
Thank you.